Good afternoon, everybody. I'm your host, the Supreme Litigant. I'd like to welcome all of y'all back to Smart Loc TV. If y'all haven't already, you already know the routine. Please go ahead and hit that like button, hit that subscription button, and turn that notification button on. I'll give y'all a few seconds to do that. All right, so let's jump right into it. Okay, this particular ebook right here was drafted by the same author of the child support book that I've been emailing everybody. And according to the author of that book, this book right here, what I'm about to read, is 1,000 times better in their own words, according to what I was told. I was also told that I can give y'all free copies of this as well. So in the comment section, there'll be a link pinned in this video to where you can click on it and download this ebook, what I'm about to read. Today, I'll be doing probably about maybe 6 or 7 pages, and then we'll just keep going from there. And I'll be providing commentary from time to time as well. There's a lot of footnotes in this book. I'm not going to read the footnotes. However, I do believe that you should read the footnotes when you get this book to understand what the author is saying in here. So, Treaties of Rhodes, tyranny no more. Disclaimer, we always have to put this in here because they just hate us, y'all. But anyway, disclaimer, not for any court use, for educational and entertainment purposes only. Chapter 1. A non-casting of children upon the public, which means government, and the nationwide police state, the child support establishment and enforcement scheme. Title 4D, a congressional legislation arising out of the Federal Social Security Act of 1975, which requires every state to manage and administer a child support enforcement program as a condition to receiving federal funding. So they created an administrative agency as a way to enforce this particular legislation. Congress legislated Title 4D in the federal interest of the general welfare to ensure that the states were pursuing absent parents who were casting their child upon the public in order to reduce dependency on welfare. In other words, American taxpayers were now footing the bill of an increasing amount of recipients on welfare because of absent parents who were failing to provide adequate and necessary support to their children, thus casting their child upon the taxpayers to take care of their parental responsibilities. As such, Title 4D was created in response, requiring all 50 states to manage a child support program to pursue absent parents as a condition to receiving federal funding in order to reduce a family's dependency on welfare. It was also created to support families. It was also created to help families avoid becoming dependent on the state because of the lack of support from an absent parent. Based on the intent of Congress's legislation of Title 4D, it is a fact that the only individuals who may be forced to pay support under state or federal police power are absent parents. Let's go and see what that footnote says. I think that's one we need to read. Footnote number 4. It is clear that families with absent fathers are the intended beneficiaries of Title 4D. But I don't want y'all to read too much in that because they're confusing you. Y'all know these are attorneys, all right? They're confusing you. But we're going to substantiate what an absent parent is, at least in this video. Non-absent parents were not and cannot be subject to Congress's delegated authority in creating Title 4D. Otherwise, it wouldn't be consistent with the 10th Amendment. With these facts in mind, this chapter asks and answers 2 questions below that threatens a trillion-dollar machine and exposes it as quite possibly a deliberate legislative design to exploit and traffic minor children for financial gain and furthered by the government's judiciary system? These are two important questions, y'all. And I'm the next page is going to, in my opinion, is going to substantiate why these are two important questions. Well, why the first question is an important question. So, what and who is an absent parent? That's the first question. And the second question is, are non-absent parents being forced to do what they have not failed to do as absent parents? Just think about that for a minute, y'all. And I want y'all to pay attention. Arguably one of the most important congressional legislations in history, strangely did not define the subject and target of its legislation. What is an absent parent? So in other words, what he's saying is Congress intentionally left the definition of what an absent parent is out of the legislation. They didn't give you a definition for it. Why did they do that, y'all? Just ask yourself why. Even more strangely, there is no court or Title 4D agency in the United States that has nor issues any hearings to determine whether any parent is absent or was made absent through no fault of their own. I wonder why. This we will discuss in the next explosive chapter. Although there is no congressional or even state definition of an absent parent in the United States, the United States Supreme Court has defined what would be a parent's absence in providing support to a child in the case of Carlson, in their stating, the nature of the absence is such as either to interrupt or to terminate the parent's functioning as a provider of maintenance and support, physical care, or guidance for the child. And the known or indefinite duration of the absence precludes counting on the parent's support or care. According to the United States Supreme Court's definition of a parent's absence, the definition of an absent parent then could fairly, or in other words, could reasonably be stated as one who interrupts or terminates his or her functioning as a provider of maintenance, care, or guidance for their children or child, and the known duration of their absence precludes counting on that parent's support or care. Let's go down a little bit more. The natural law in speaking on a parent's support of a child has been clear in more than several dozen jurisdictions, and it is the most important source to the answer of our first question. What is an absent parent? This is because the natural law provides that there are two distinct acts that must occur before parents can ever be absent parents. 1. A parent must refuse to take custody of their child, and 2, refuse to render them a proper support. Even more importantly, these two distinct acts fit within the description of the U.S. Supreme Court's definition of a parent's absence in the case of Carlson, providing substantial legal weight in our sources arising from the natural law. Furthermore, because the case is speaking on the natural law, touches more so on common law existing in the laws of nature, pre-existing government, its cites provides a powerful legal authority for all jurisdictions. As a starting point, we arrive at the 1889 Indiana Supreme Court case of Ramsey speaking on the natural law and two distinct acts of a parent that would fit the definition of an absent parent in its stating. The father has in some way manifested his purpose to abandon their child, or has refused to take them into his custody and render them a proper support. I think that's a pretty good definition right there. That's just my opinion. Here we have two distinct acts as previously stated, describing an absent parent as it exists in natural law, to wit, 1, a parent refuses to take their child into their custody, and 2, refuses to render them a proper support. So there's a footnote 8. Let's see what number was it? Number 7 and 8. I'm gonna see what number 7 and 8. See what number 7 and 8 says. Okay, so he's citing the case right there. And number 8, let's see, abandonment need not be included because the act and definition of abandonment does both distinct acts above by default, refuses custody of a child and the rendering of a proper support. Okay, I see what they're saying. The Indiana Supreme Court case of Ramsey further describes these two acts and a fact situation that surprisingly applies to millions of fathers across this country currently. Ramsey stated that when a man abandons his child and casts it upon the public, he becomes liable for its support. But this is the equity part right here, y'all. This is the equity part. But it is entirely impossible to treat a child as thus cast upon the public when the fact simply is the mother has deserted the father and carried away the child and continues to support it. So in other words, it's not the father's fault. And since it's not the father's fault, he is, as a matter of equity, because equity judges in righteousness. Equity deals with what's just and fair and proper under the circumstances. And wouldn't you think that it's just, fair, and proper under the circumstances that you be relieved of the duty to support a child because the mother has, without any lawful purpose, I'm going to say that, or without any justification, has deserted you and secreted the child away from you? Isn't that the equitable thing to do? Ask yourself that, because that is certainly an equitable thing to do to me. I'm not telling you to do this to get out of paying child support. Not child support, to get out of taking care of your kid. But there are millions of fathers all across this country in which this circumstance, in which this right here is applicable to, as the author just said. I've dealt with that before, to be honest, which I don't like to talk about it, but I've dealt with that before. But anyway, let's get back to it. What Ramsey provides is that no father can be an absent parent if the mother has deserted the father and carried the child away. In this instance, a parent has not refused to take custody of his child and render them a proper support according to two distinct acts that must occur according to natural law to be according to natural law to be an okay, so he forgot an absent parent, right? According to natural law to be an absent parent. I'm guessing that's what the author tried to say. Rather, the parent's functioning of a provider of support and maintenance has been interrupted through no fault of their own, according to Carlson's definition of a parent's absence. According to the reading of Ramsey, in its speaking on the natural law of a parent's support of a child, a man cannot cast his child upon the public through acts that were no fault of his own. I completely agree with that. And thus, it only follows he cannot be an absent parent within the meaning of Title 4D. And the author is absolutely right, y'all. I agree with this. I agree with this 100%. The author is right. Hopefully this makes sense for y'all. I know, like a lot of men that are watching this video, this is going to make so much sense to you. But the problem with you're probably going to have a hard time arguing this. And I get emails all the time asking me, is this applicable in this state or this state or this state? That is a principle. That is applicable everywhere. That is an equity principle. I haven't seen any case that clearly says that is an equity principle, but I can tell you it sounds just like an equity principle. For example, I always use this example. So in Alabama, they have what they call an out-of-time appeal, meaning they will let you file your appeal out of time if the delay for filing the appeal was through no fault of your own, meaning it's not your fault that you're filing the appeal late. That is equity. So let's see, where are we at? Okay. I'll do about 2 to maybe 3 more pages. Give me a second, y'all. Let me pause the video, get a drink of water. I'll be right back. All right, y'all, back. I'm back. Sorry about that. Today, Ramsey proves so much more than merely describing one who cannot be treated as a parent who casts their child upon the public. It proves that possibly millions of fathers across this country are currently being forced to pay support under Title 4D, although they were made absent through no fault of their own, but fault of their child's mother that kept them away from their child or children. Even mothers have been made absent parents by acts of their child's father in certain circumstances. I completely agree with that too. Shockingly, what the natural law proves is that any parent who has kept their child away from the other parent for no legitimate purpose has been awarded for doing so in the form of monthly child support payments coerced under state police power through contempt proceedings. I agree with that too. This is explosive news and will send shockwaves and threaten a very lucrative family law industry to its core. What this means is that possibly millions of parents have had their assets, income, and property all awarded to the other parent for that parent's engaging in acts that many doctors and psychologists today call parental alienation of a child. Also, let me tell y'all something. If that is happening, those are called iniquities. So let me show you what I mean by iniquities. I'm gonna pause the video and I'll be right back. All right, y'all. I said the word wrong. I'm sorry about that. Inequity. All right. The reason why I say that is inequity, if you ask me, like if you were to take whether it's the mother or the father to court, it could be because they're violating your natural rights as a parent or whatever. I would do it in a court of general jurisdiction, in a suit, in a bill of equity. I would file a bill of equity, and I would explain the facts and circumstances. I'm gonna read this to y'all again, just to explain this to y'all. What this means is that possibly millions of fathers have had their assets, income, and property all awarded to the other parent. That is unjust enrichment, y'all. Unjust enrichment is a cause of action in equity for parents engaging in acts that many doctors and psychologists today call parental alienation of a child. They're keeping the child away from you. And since they're keeping the child away from you, they should not be awarded that, because the act of keeping the child away from you for no legitimate purpose is inequitable. Do y'all see what I'm saying? He who seeks equity must do equity. He who comes into equity must come into equity with clean hands. This whole child support thing, it's quasi-equity jurisdiction, if I'm not mistaken. I want to say I'm about 99% sure of that. And it's an extremely limited quasi-equity jurisdiction because it's a state. It's not a court. It's an administrative agency. All right. So administrative agencies, or in other words, inferior, they call them inferior courts. But anyway, inferior courts are courts of limited jurisdiction, not general jurisdiction. All right. So let me get back to this right quick. I'm gonna read it to y'all just a little bit more, and then I'm gonna stop. The reason why I say it's inequity, it's inequitable. All right, it's not equitable. Inequity means injustice or unfairness. In a legal context, inequity signifies injustices that are sufficiently recognized to justify a remedy. All right, so why should you be forced to to pay child support or to have your assets seized or just anything like that because the other parent is refusing to allow you to be a parent? That's inequitable. So let's get back to this ebook. Let's see. Shocking. I agree with that. 1929, the 1929 Georgia Supreme Court case of Hooten goes even further into the natural law, again describing the two distinct acts that must occur before a parent can be made an absent parent. However, Hooten outright states that a parent is relieved from the duty to support if deprived of the custody of one's child through no fault of their own, because that is the equitable thing to do. That is the fair and just and righteous thing to do, because it is not your fault. Is it fair to send you to jail for some shit? Pardon my language. Is it fair to send you to jail for something that you did not do? Is it fair to blame anybody for something that they did not do? That is inequitable. And God judges inequity. It literally reads as follows: right, the custody and the earnings of his minor children are reciprocal, and that whatever deprives the parent of the right to the custody and the services of the child without fault on his part relieves him from the duty to support the child. That is equity. That is equity. Even the 1984 Supreme Court of the New Hampshire case in Siciliano supports that notion that a parent's obligation of support is contingent on the parent actually retaining custody of the child, thus providing supporting authority for their sister Supreme Court in Georgia in its Supreme Court case of Hooten, that a parent is relieved from the duty to support if deprived of the custody of their child through no fault on his own. This case too literally states, to wit, the obligation of a parent to support and educate the child is contingent upon the parents actually retaining custody of the child. I agree with that. The Georgia Supreme Court in Thompson again speaks on the natural law of a parent support. I'm sorry. Let me read this again. The Georgia Supreme Court in Thompson again speaks on the natural law of a parent's support of a child in stating, to wit, the right to the services of the children and the obligation to maintain them go together. Whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. And there's a footnote. If you're going to read the footnote, I'm pretty sure that there's going to be the case citation. So let me go down there and just double check. Now they're going to be the case citations down there. Let me scroll back up because I want to show y'all something. I got to point this out. All right. This is the New Hampshire Supreme Court in 1984 citing a Georgia Supreme Court decision. All right, because that's a principle. That's why they did that. That is a principle. That's why they cited it. So if you're looking at this video and you want to know if this is applicable to your so-called particular state, yes, it is. The next question would be to ask yourself, do your facts justify you seeking this particular remedy in these so-called courts? I would not even file this in child support court. I would file it in a court of general jurisdiction, which is a court that was created under the common law via the Constitution, via the sovereign people of whatever particular state that you're in, I will file it in the court of general jurisdiction, which is aka a superior court. All right. Courts of general jurisdiction hears all types of cases. They hear common law cases, equity cases, maritime and admiralty cases. All right. That's where I would file it at. Let's see. And I will file a bill in equity. That's what I would call it. I would file a suit and a bill in equity. And that's what I would do. What is clearly being shown is that these two distinct acts, one, refusing custody of a child, and two, failing to render them a proper support, not only must occur before a parent can be an absent parent, but if it occurs through acts of a parent who deprives the other parent of the custody of their child through no fault of their own, then that parent is relieved from the obligation and duty to support pursuant to natural law. So in other words, what he's saying is if you're a parent and you're depriving the other parent of custody of their child, then you have no right to petition any of these administrative courts or any court of general jurisdiction for a remedy if you're doing it for an illegitimate purpose. Meaning if you're withholding the kid from the other parent for an illegitimate purpose. You know what I'm saying? You have to have, I mean, it has to be reasonable. Is she or he abusing the kid? Are they drinking around? Are they doing something that is just inappropriate around the kid? Something like that. I agree with that. You see what I'm saying? It provides that when and why a parent must pay support. The when and why a court can force a parent to pay support, and when and why that parent is relieved from the duty to support. As the Georgia Supreme Court case of Hooten explains, custody of a parent's child is a reciprocal obligation for that parent's duty to support the child. This reciprocating obligation stretches all the way back to ancient English common law origins, when originally only the father of the child was entitled to his child's custody. Now that is crazy. Commentary writer James Kent, frequently cited by early 19th century jurists, emphasized the mutuality of that parent-child relationship. Kent wrote that because the father's obligation to provide for the maintenance and the education of his child, he was entitled to the custody of their person and even the value of their labor, i.e. services, if they worked for any employers. Thus, the right to a child's custody and labor was therefore seen as recompense for the father's obligation and duty of support. Okay. Let's go. I think I'm going to stop on page, let me see how long this page is. I think I'll stop on page 7, or we'll do page 7 and then I'll stop, y'all. And then we'll do another video either tomorrow or later this week. To make this more sensible, metaphorically speaking, it is true that no property owner can be expected to pay mortgage to a landlord that has deprived him or her of their rightful possession of the property. This is not to be taken as to regard children as property or chattel, but to associate the example with the fact that a parent too could not and cannot be expected to provide support for a child while he or she is being deprived of the rightful custody and or services of the child through no fault of their own. To even state so allows the assuming of all obligations of parenthood, which includes payments of support while depriving that parent of the custody of their child, which is equivalent to denying the parenthood itself. I agree with that. Today, both parents are now entitled to the custody and services of the child. Therefore, this recompense and reciprocating obligation now applies to both parents. This recompense demonstrates in established legal precedents in multiple state Supreme Courts that a parent's duty to support the child is contingent on the parent actually retaining custody of the child, and also that whatever deprives the parent of the right to the custody of the child through no fault of their own relieves them from the duty and obligation of support. In reading and comprehending the authority and natural law, it shows and proves that a parent is only responsible for his or her child while the child is in his or her household or custody, not while the child is in the other parent's household, unless 1, he or she refuses to take custody of the child, and 2, refuses to render the child a proper support. I agree with that. If we deliberate on what we know so far, it becomes quite clear, comprehensive, and sensible of why this is so according to natural law supported by the Supreme Court cases cited, and why the entire family law industry must reform and revamp its entire system when this knowledge becomes privy to the public at large. It should follow why this industry, which has been called I'm assuming they might have left something out. They probably left something out. For hypothetical purposes, let's state that 2 parents divorce or 2 unwed parents separate and gets 2 separate households. The child now lives equal the amount of time in 2 households with his or her parents. As equals, they both share in responsibility, support, and care for their child that they both equally created. I agree with that. Parent A gets the child 15 days on rotating months. Parent B gets the child all the remaining days on rotating months for an equal of 182 days a year. If parent A refuses custody for January, February, and March, of course, parent B now receives the burden of parent A's responsibility. And if parent A now refuses to render a proper support to parent B when requested, making parent B more prone to seek or actually seek welfare assistance, parent A is now an absent parent within the meaning of Title 4D. Let's also say parent A consistently asks parent B for the custody of the child. However, parent B refuses for no legitimate reason for several months. According to natural law, not only is parent A relieved from the duty and obligation of support, but parent A cannot be an absent parent within the meaning of Title 4D because parent A has been made absent through no fault of their own. This making sense for y'all? This making sense to me. Quite frankly, parent B has alienated the child away from parent A in that this instance, just as no parent can be an absent parent if they have not refused to take custody and render their child a proper support. No parent who has lost or even deprived, no parent who has lost or been deprived of the custody of their child through no fault of their own can by definition be an absent parent within the meaning of congressional legislation of Title 4D and according to natural law and the cases cited. I completely agree with that. All right, y'all, that's gonna be the end of this video. I'll start back probably tomorrow or later this week. And if you want a copy of this ebook, you can download it. There'll be a comment pinned in the comment section of this video for you to download. There's a lot more information on this. There's a guy actually litigating a case in Georgia right now arguing this same exact thing. And guess who it is? The author of this book. Y'all need to pay attention and wake up. The Supreme Litigant is out. Peace.